Hello everyone, welcome to Court with Krissy. This one definitely will not leave you with a warm fuzzy feeling. The story's a little knocking thoughts. The defendant tried to access his victim in the morgue by posing as a Michigan State Trooper. This is his sentencing. And if you looked at his MDOC image, he does not look like a healthy boy. I'm guessing he's going to die in prison. I hope you like it. Court with Krissy is now in session.
Thank you. And you are John Dominic Bromley.
Yes, Your
Welcome, Mr. Bromley. We're here for sentencing today. Have you had enough time to go through the PSI with your attorney?
Yes, I have.
And your attorney has requested to appear via Zoom. He informed me, I think it was late last week, but it was last week in time for me to consider that he had another very serious matter, and therefore he was asking to appear via Zoom. Were you aware of that?
Yes, I have.
And is his appearance with Zoom with your ability or with your consent or agreement?
Yes, Your Honor.
And Mr. Frago, is it accurate you had another conflicting court date? That's why you were asking to appear via Zoom today?
Yes, Your Honor, at 8:30 a.m. in Chippewa County.
Okay, I couldn't remember the exacts, but I remember allowing you to appear via Zoom. I also have on the Zoom screen somebody listed as Jamie Lynn. Miss Lynn, I am of the understanding that you are the daughter of the victim in this case. Is that correct?
Yes, Your Honor.
Okay, thank you. And I also have somebody named Daniel, I believe it's Lutke, or Lutz, I'm sorry. Mr. Lutz, are you the brother of the victim in this case?
Yes, I am.
Okay, welcome. I received information from the crime victims advocate that Miss Lindy and Mr. Lutz were asking to appear via Zoom, and I approved that as well. Ms. Worker, were you aware of that?
Yes, Your Honor.
Do you have any objection to that?
No, Your Honor.
Mr. Frago, were you aware of that?
Yes, Your Honor.
Do you have any objection to that?
No objection.
All right, and so what we'll do is take up first the scoring challenges, then we'll take up the body of the report, then I'll hear from the victim's relatives, then I'll ultimately hear from the prosecutor, the defendant, the defense attorney rather than the defendant last before I impose sentence. So let's start with the challenge to the guideline scoring. Mr. Frago, I received a written copy of your objection to OB3. I received the prosecutor's response. I've gone over case law on my own as well as the body of the PSI, of course, in advance of the hearing today. I'm familiar with OB3 and what's necessitated, but I would allow oral argument to supplement the written record if you would prefer that. Mr. Frago, did you have oral argument in support of anything additional?
Nothing to add, Your Honor. We'll stand by our brief. Thank you.
Ms. Brooker, in response, did you have anything to add, or do you also stand on your written brief?
Nothing additional. Your Honor.
So the court would note that OB3 is scored in all cases, and the question the court has to ask starts with the standard of review, and that is a preponderance of the evidence. The court has to find by a preponderance of the evidence that the factors as outlined in OB3 are met. In this particular case, the disagreement centers on whether or not OB3 should be scored properly at 100 points. The department did recommend scoring at 100 points. And in order for the court to score 100 points on OB3, the court has to find that the victim was killed and that the sentencing offense is not a homicide. We already know, and the attorneys essentially concede in the written briefing, that this offense is not a homicide. A homicide is defined statutorily as any offense which necessitates a finding that there was a death. In other words, there was a requirement of a death. It says score 100 points if death results from the commission of a crime, and homicide is not a sentencing offense. Any crime in which the death of a human being is an element of the crime is a homicide. And the attorneys obviously understand and agree in this offense, the defendant was convicted of vulnerable adult abuse, first degree. That is not a homicide. So the question is, by a preponderance of the evidence, is there a finding that the court could make from the pre-sentence investigative report, the other information that's been provided, or from hearing from victims that a victim was killed as a result of the sentencing offense? Those words are also important, as noted, at least as argued by the prosecutor. There is a difference in the terms of the prosecutor's argument under cited case law between as a result of, in terms of factual causation, or approximate causation. And the prosecution cites People versus Wood. Defendant, on the other hand, suggests that the PSI, as well as the amended postmortem investigative report, indicate cause of death is bilateral acute bronchopneumonia, and therefore the victim's death was not caused by the defendant's assault. The court is aware that I can take into account all information contained within the PSI in making a determination by a preponderance of the evidence standpoint. That information in this case consists of several different points of information as it relates to OB3. Relating to OB3, the court notes that the PSI under evaluation and plan indicates that the victim was diagnosed with numerous broken bones, multiple fractures to her spine, fractured humerus, and skin that was in various states of decay due to not being bathed. It should be noted that the victim was seen in the emergency department at the Otsego Memorial Hospital on June 4th of 2024 for possible placement. He returned on June 5th, 2024 and was diagnosed with above injuries. Trooper Kuhn, the investigating officer, was then later notified on 6/20 of 2024 that the victim passed away unexpectedly. The defendant was cooperative, immediately knew he was picked up when he was found. Later, he waived his Miranda rights, agreed to be interviewed. He was immediately cooperative, immediately knew why he was picked up because of the things that had transpired between him and the victim. He indicated they'd been together for over 30 years and had an arduous relationship, resulting in her leaving a lot and then getting back together. Also, Trooper Kuhn had indicated that when asked to explain, the defendant admitted that they were staying in a friend's cabin. He was drinking. The victim upset him and he pushed her down. Trooper Kuhn told him that the victim indicated that he had a fit of rage, and he said that was likely true. He, being the defendant, admitted that he had an anger issue when drinking and admitted that the devil takes over when he's drinking excessively. He indicated he regretted pushing her down and he knew she was injured. During the interview, the defendant denied kicking the victim, but later in the interview, he said he couldn't remember how many times he kicked her. He acknowledged knowing she had serious injuries and possible broken bones, but didn't seek medical attention. He expressed concern to Trooper Kuhn about losing his job, and Trooper Kuhn told him that the victim lost her life. The defendant replied, quote, "Yeah, but she was headed that way anyway. I might have added to it, but she was not a healthy girl," unquote. The prosecutor then was presented with authorization and suggestions on charges, ultimately charged as was indicated in the court file. The defendant then pled guilty before me for the first-degree vulnerable adult abuse by stating, in short, that he pushed the victim down, that pushing caused significant injuries, which convinced me that there was an adequate factual basis for a vulnerable adult first degree. Whether viewed through the lens as suggested by the prosecutor under the case of People versus Wood, or even viewed through a different lens in requiring a fact finding of proximate causation, under either scenario, the court finds sufficient probable cause and preponderance rather of the evidence to score OB3 at 100 points. Specifically, the court relies upon the defendant's own statements, and the defendant's own statements that while she may have been headed that way, that is to death, his actions might have added to it. That combined with a copy of what was provided by the prosecution and referenced by the defense of the medical cause of death findings, the amended findings, the cause of death is clearly and unambiguously listed as bilateral acute bronchopneumonia. However, under conclusion, the following information is included. Based upon the autopsy findings and the history as available to me, it's my opinion that Robin C. Bromley died as a result of bilateral acute bronchopneumonia. Multiple injuries, including left humerus fracture, bilateral rib fractures, chronic obstructive pulmonary disease, hyperextensive arthrosclerotic cardiovascular disease, and dementia were contributing factors. Later in that same paragraph, the conclusion was post-mortem examination report reported the injuries, and specifically the humerus fracture that the decedent sustained occurred during an assault by another, here the defendant. For public health and vital statistics purposes, the manner of death is best classified as homicide. So while initially the amended report and the report suggested a cause of death is bilateral acute bronchopneumonia, it also specifically and unambiguously indicated that contributing factors were the rib fractures, multiple injuries, including left humerus fracture, those which were clearly and directly caused by the criminal acts of the defendant, pushing her down, knowing she was seriously injured, not taking her in for further care. So while there is some merit to the defense argument that there could be an argument that there's not proximate cause, again, by the low standard of proximate causation, by the low standard of preponderance of the evidence, the court still makes the finding that OB3 is properly scored at 100 points. But for the actions of the defendant, the decedent would not likely have died. She did die from something, not only the injuries caused by Mr. Bromley, but those were certainly exacerbated by even under the defendant's own version of the events. For those reasons, OB4 is properly scored at 100 points and the defense objection is overruled. Outside of that, did you have any other additions, either additions, corrections, or deletions to the body of the report or other challenge to scoring, Mr. Fregel?
No, Your Honor. No.
Do you have any other additions, corrections, or deletions to the body of the report or challenges to scoring, Mr. Fregel?
Yes, the body of the report, Your Honor. I would just note under pending charges, it does indicate that he has a charge for false impersonation of a police officer pending. He also has another warrant for his arrest out of the Commonwealth of Pennsylvania, Bucks County, for making terroristic threats with intent to terrorize another. He's not been arrested on that yet, but I did want to make sure that was added. I have a copy of the warrant. The court would like to see it. Mr. Fregel already has a copy of that. That was in his discovery materials.
Mr. Frankel, were you aware of that warrant?
Yes, Your Honor.
Do you have an objection to the PSI being updated to indicate that there's a warrant from Pennsylvania for those charges?
No, Your Honor.
The court will add that clarification. Then I'll be very clear, though. I think it's factually accurate and necessary to have it be updated. There are pending charges. My sentence will not reflect anything to do with pending charges. I understand why it's important for me to know of those pending charges, but I'm going to issue sentence in this case based upon these facts in the sentencing offense alone. But I understand again why the prosecutor would want to have this PSI be accurate. Any other corrections, additions, or deletions?
Nothing else, Your Honor.
And on behalf of the people, I'll hear allocution from both of the victims that are here today, and then I'll hear prosecution's allocution. Ms. Lindy, as the daughter of the victim, did you wish to be heard by way of allocution? Did you want to tell me anything you think I should know about how this offense has impacted you or the greater community at large?
Yes, Your Honor.
Thank you, Ms. Lindy. I appreciate you being here. What should I hear from you?
Okay. Dear Judge Hunter, I want to write you as the daughter of Robin Cheryl Bromley and as a single mother of 2 young girls, all of whom have been permanently impacted by the actions of John Bromley. My mother was a respected therapist and a reasonable contributing member of every community she's lived in. She financially supported their household wherever they moved. I don't recall John ever holding a steady employment as a carpenter or builder. Behind closed doors, my mother was subjected to relentless physical and emotional abuse by the man who claimed to have loved her. She kept surviving until she couldn't anymore. Although my mother and I were not especially close, she tried hard in recent years to reconnect with me and build a relationship with my 2 daughters. I never imagined I would have to face death the way that I did, alone, afraid, carrying the burden of everything John had put her through. Over the last 4 years, my uncle Dan and I lived in a constant state of unease. We never knew who would call next. A gas station attendant, a nurse, a doctor, a landlord, a neighbor, a police officer, a hospital receptionist, or someone from her room in a homeless shelter. Always someone trying to reach us about my mother. Each call brought fear, confusion, and dread. Our stomachs would drop every time the phone rang. No one should have to live like that, never knowing whether the next call would be me for another crisis, another injury, or worse. That was our normal for years. It was a direct result of the chaos and harm that John created and sustained. According to publicly available records, when Michigan State Police responded to objective squatting situation in a cabin in Oswego County in June of 2024, they found my mother bruised, barely breathing, and struggling to speak. After speaking with the physician at Munson Hospital in Traverse City, I learned the long and disturbing story of how she'd been transferred there from the local county hospital due to the severity of her injuries. My mother disclosed years of ongoing physical and psychological abuse while she was at Munson and during previous hospital admissions as well. Days after, I learned that she was there and then she was gone. After her death, John impersonated a state trooper in an attempt to gain access to her body in the hospital morgue. This was a bizarre and disturbing act that only deepened the trauma for those she left behind. But his abuse didn't end with my mother's death. On July 8th of 2024, he called me 8 separate times. During those calls, he claimed to have ties to the Italian mafia and threatened to kill me the way he killed my mother. He made repeated anti-Semitic remarks, stating that I had no right to be involved in her burial as a Jewish woman and that she hated me and wouldn't want me at her funeral. Those were not emotional outbursts. They were calculated, hateful threats intended to terrorize me simply because I was forced into her role of next of kin. Those calls changed my life. I became a licensed gun owner for the first time, not because I wanted to, I no longer felt safe. As a single mother raising 2 daughters, I have lived with the constant fear that this man might one day follow through on his threats. I have spent countless hours in therapy trying to process what happened and to create a sense of security for myself and my children. Your Honor, I did not choose any of this. I did not choose to manage my mother's affair under such horrific circumstances. I did the best I could for myself, for my daughters, and in honor of a woman who deserved much more. And though it pains me deeply to say this, I believe she is safer in a more peaceful place now, free from the suffering her husband inflicted on her for far too long. John Bromley is not a man who made a mistake. He is someone who systematically destroyed another human being. A woman who was just 90 pounds and far too small and weak to defend herself, as he continues to cause pain to those around her. I urge you to sentence him to the fullest extent the law allows. He deserves no leniency. My mother deserved protection. She didn't receive it in time, despite her efforts. I can only hope this court ensures that no one else suffers at his hands. Thank you for your time and for listening to my voice.
Thank you, Ms. Lynn, for being here and expressing that view of the case and the background that you provided. Mr. Lutz, did you wish to also offer a victim's impact statement as a brother of the victim?
I do not, Your Honor. My niece Jamie has outlined the sad story very well. Therefore, I have nothing further to add at this time.
I also appreciate you being here as well. Even though you're not providing your own statement, it's clear to me that this crime has affected each of you, and I thank you for your insight into the matter.
Thank you.
Ms. Brooker, on behalf of the people, did you have elocution?
Just briefly, Your Honor, the guideline range is 36 to 71 months. I would urge the court to consider sentencing him towards the upper end of those guidelines for a few reasons. As Ms. Lind touched on, the state police first got involved in this case based on a squatting complaint here in Otsego County. When the troopers arrived to investigate that case, they could tell immediately that Robin needed medical care. They could see right away that she was frail, that she had some type of injury, and that she needed help right away. And they called an ambulance for her. So not only did defendant inflict these injuries on her, he did not get treatment for her after he did that, and he allowed her to continue to be in agony and in pain until the state police happened to show up and investigate his complaint. Once she was hospitalized and brought over to Munson, he had some contact with her over the phone. The staff overheard him apologizing to her and saying, "I'm sorry," but they also overheard him trying to coach her on what to say because there was a police investigation that was going on. Robin was reluctant initially to talk to law enforcement and the hospital social worker about the years of abuse, but eventually she did open up and admit that defendant had been the one who injured her and assaulted her. And then, like Ms. Lind had touched on, some of the bizarre things he did after her death, including, continuing the torment that her daughter had about her mother dying in general by calling her, threatening her, causing her to fear for her own well-being after dealing with the death of her mother. I think all of those factors would account for a sentence of that upper end of the guidelines, and I would ask the court to do that.
Thank you, Ms. Brooker. Mr. Fragel, on behalf of Mr. Bromley.
Thank you. Your Honor, I would ask the court to consider the defendant's psychiatric condition. He and the victim roamed throughout Michigan and other states, basically homeless for a significant period of time. They were found as squatters at an old friend's cottage in Otsego County. Their property was stored in a U-Haul that could not be moved from the home. And he himself has had demonstrated loss of memory and obviously loss of temper here. So if the court is going to sentence him to prison, we would ask that he get some psychological evaluation and treatment thereof. He's 75 years old. He has only one prior drunk driving conviction. To me, he has apologized profusely for his behavior. Some of it he remembers, some of it he doesn't. He did admit to the officer, the trooper, what he did. He was cooperative and is remorseful for that. Given that he's 75 years old, I think a 6 or 8 year sentence would perhaps be a life sentence, given the frail nature of his build right now. I've seen him lose significant weight over the last 4 months that I've represented him. So we would ask the court to err on the lower half of the guidelines, given the facts that are in the defendant's favor. And again, as brutal as this was, as heartless, almost more heartless than it was brutal, to treat someone like that. It is his first offense, and he is apologetic for it. So I would ask the court to give him some opportunity to be released from prison and wrap up his affairs in a dignified manner. Thank you.
Thank you, Mr. Fragel. Mr. Bromley, was there anything that you wanted to tell the court before I impose sentence today?
There is. I'm very sorry for what I've done. I apologize. I don't know what else to say. The circumstances were hard to explain, but and I don't know what else to say.
Thank you, Mr. Bromley. I've had a lot of time to understand the background of the offense, to try to assimilate all the information that's within the PSI and now add to that the long and, I thought, well-stated, eloquent discussion by Ms. Lind of how this crime has affected not only her, but the community in general, her own children, how it's affected her uncle, Mr. Lutz, how they have had to live through these circumstances, not just of this instant offense, but through your pattern, as she described it at least, of ridiculous, abusive behavior for years. It doesn't surprise me necessarily that what you tell me is you're very sorry for what you've done and that you don't know what else to say, because when contrasted with the depth and detail provided by Ms. Lind, the depth and detail provided in the medical reports and the PSI, the pre-sentence investigative report, it doesn't surprise me that words like "you're very sorry for what you've done" don't tend to capture what I would view as any realistic form of taking of responsibility. I have to make a judgment call and a credibility call in every sentencing case and in every case that's before me, and I have to determine, at least in my mind, as it relates to the element of rehabilitation, whether or not I think you're taking responsibility. Oftentimes that calls for me deciding whether I believe what you've said. I believe what your attorney said. What your attorney said is that to him, you've expressed remorse and taken responsibility. I understand that you took responsibility in terms of the plea by pleading guilty to the pure factual basis for the vulnerable adult abuse first degree. The words you said at that plea was that you pushed her down and that she was injured. I think that clearly stated is a ridiculous misrepresentation or under misrepresentation of the extent of what you did. The extent of what you did was captured in the PSI and is captured in medical records. You lost control of yourself as a violent alcoholic, and you couldn't remember how many times you kicked your wife for many years. You kicked her to the extent and pushed her to the extent that she had extreme injuries that you knew were serious, including broken bones, yet you did nothing to call attention to that or to ask for help on her behalf. Her injuries were so severe that she, as reported through the PSI, begged to die and eventually did succumb to her injuries through a combination of things that you forced upon her, the physical grievous injuries, and through a combination of her own frail medical condition. And on top of all of that, the grievous, ridiculous injuries that you committed upon your wife without seeking, offering, or calling for medical help or intervention, in essence, ignoring the grievous pain she was in, the acute injuries that you caused, when you're interviewed about it later, as if my reaction to my view, you're not taking any responsibility at all, then are interviewed by the police, tell them you don't know how many times you kicked her, also after they confront you, and tell the police after they tell you your wife was dead because of, at least in part, your decisions and your actions, you tell the police she was headed that way anyway, and I might have added to it. In my nearly 10 years on the bench, having presided over multiple death cases, I can't recall having heard a more pathetic offer at a justification or a more heinous reaction, more disturbing reaction to a notification that your wife was dead. She was not a healthy girl. She was headed that way anyways. Those are words that would haunt, should haunt anyone who comes across them. I'm positive that they do haunt Miss Lind. I'm positive they do haunt Mr. Lutz. And anyone that has the occasion to hear or read of this case, to hear that the person who is supposed to be protective of and caring of an individual would be so disconcerted by her death that you report that she's a sick girl anyways, and you might have added to it that she was headed that way anyways. That speaks to a level of disgust that I can't explain, but I can only feel. And that feeling, again, is part of the reason why any words that you say that you're sorry for what you've done are not found compelling by me in any way. In fact, they're utterly not compelling. They speak to no potential rehabilitative goal. In fact, nothing that I've reviewed in the pre-sentence investigative report speaks to any rehabilitative goals being met or any chance for rehabilitation. Yes, it's true, and the guidelines reflect that before this offense, you had one conviction for operating while intoxicated. So the guidelines are accurately scored. They take into account your lack of criminal history. But outside of the OV points that are scored, they can't possibly capture that disgusting response that you offer as soon as you're interviewed by police in Wade Miranda. That she was not a healthy girl, and you might have added to it that she was headed that way anyways. OV-19 is properly scored because you tried to convince Robin not to report your abuse that led to her death to police. I can't account for it any further, even though I certainly take into account Miss Lynn's statements that you called and harassed her and threatened her and that she became a gun owner because of it. I can't double score OV-19, even though there's certain circumstances that are not even taken into account in OV-19. I can't score any more for OV4, their serious psychical injury that you caused to Robin Bromley. She was so injured that she told the medical provider she wanted to die. I can't account for the death of Miss Bromley any further. I've already scored 100 points for OV3, and that's a correct scoring because your actions caused in part her death. So I can't account for that any further. The question is whether or not, when I account for those things, those properly underscore the seriousness of the offense, the background of the offender, the effect that this type of a crime has on Miss Lind, Mr. Lutz, the entire community of Otsego when they have recounted this horrific circumstance, and whether or not the guidelines I scored are even adequate given the circumstances. In the end, I find that the guidelines are adequate, but anything other than the maximum guidelines range is completely inadequate. So while your attorney is a good advocate and does a good job advocating for you to be able to find peace, the peace, or more specifically lack of, that you left Miss Bromley with and the circumstances, as I've already described about your reactions when confronted by police, lead me to believe that peace is something that you don't deserve. It won't be up to me after this hearing is done. It will be up to the Department of Corrections whether or not they ever determine to allow you to have parole. But for given the circumstances that I've gone over already, your reaction to them and my clear disbelief at any claim that you're very sorry for what you've done, anything less than the maximum of the guidelines would be an insincere sentence and an insufficient one. So it is this court's sentence that you'll be sentenced to the Michigan Department of Corrections for a minimum term of 71 months in the Michigan Department of Corrections. That's the maximum under the guidelines range. And while I have reasons why I think that those guidelines ranges are not ultimately enough, again, I am somewhat constrained by the scoring of the guidelines and the factors I've already outlined. So 71 months minimum, 15 years maximum. You do have credit for 177 days that I will award that you previously served. State mandatory minimum fines and costs are awarded as follows, or ordered as follows: a crime victim assessment of $130 for a cost of $325, a DNA testing fee of $60 and a $68 state cost. State law requires that those fines, costs, and assessments are paid within 56 days of today's date. If they're not, a 20% rate fee gets added on. You have the ability to ask the Court of Appeals for leave to appeal. The court officer is going to hand those to you. There's 3 different copies. The top copy you signed to indicate that you got your notice of appeal rights. The bottom 2 copies are yours. If you wish to ask for permission to appeal, you can fill those out in their entirety and turn them back into the court within the time stated. Mr. Fragel, we will have the defendant fill out and we sign the top copy, and then we'll send those appellate rights with him. Did you have anything further for the court record today?
No, thank you.
Ms. Brooker, did you have anything further for the court record today?
No, Your Honor.
Please make sure Mr. Bromley has his bottom 2 copies and that top copy can go back to the clerk.
Yes, Your Honor.
You're remanded to the custody of the Sheriff's Department until they can arrange for your transport to the state prison system. Ms. Lindy, Ms. Lutz, thank you again for being here and providing your insight in this case. You're free to sign off now.